Thank you. This is Greg at Bradford Barthel. I'd like to have each person introduce themselves.
Good afternoon. I'm Diane Cohen with Macro Pro Document Retrieval Company.
I am Sal Alvarez with ILENGO2.com, Language and Transportation Solutions.
And I'm Manuel Rodriguez. I'm an applicant attorney. I've been representing injured workers since 1992, along with their workers' compensation matters.
And for me, I should probably introduce myself. I'm Greg, Certified Specialist Defense Attorney for almost 20 years now. And today's presentation is kind of the avoiding landmines of the AME QME process. I've listed here all of the labor codes. We're not going to dive too deep into the language of the labor codes. Hopefully everybody out there understands those labor codes, has worked with those labor codes. So this is just a quick review of the labor codes we're going to talk about: 4060, 61, 62, and the other ones. If you're not familiar with these, just reach that labor code book at your desk that I'm sure you have and dog-eared to read those codes. And if you have any questions along the way, please type that in and we'll try to get it at the end. And what we're talking about is really for dates of injury after 1/1/2005. There's different rules for pre-1105, which would be a different presentation. So if your date of injury that you have is pre-1105, then consult the adjuster next to you or contact your favorite defense attorney to talk about the process on that. And with that, everybody here has a disclaimer. What we say today is not legal advice on any particular case. You should not rely on anything we say as legal advice in this presentation for your specific case without consulting your defense attorney to determine if that's the best strategy for your specific fact pattern or case history. Any strategy could completely change with any issue, fact pattern, and history. So we're just talking about general strategies today, but if you have any specific questions on specific cases, then please consult somebody on that and don't rely on what we say today. So that's my get out of jail free card. Hopefully everybody remembers that during the presentation. That applies to all the speakers today. So the AME QME process for 4060 denied cases. When do we get a panel and what specialty do we want? What you want to watch out for generally is those mean applicant attorneys getting Cairo panels. And that's part of the reason why we have a applicant attorney here today to get their perspective. It's not really, it's really a general perspective, not specifically what he does in his case. So he could get his own disclaimer, but we're just talking general strategies on cases. I find some applicants' attorneys like to use chiropractors or pain managements right away. So, man, what's your general sense of the applicant attorneys out there and using chiropractors and pain management doctors?
Well, I know that on the defense side, the ideal would be to get an orthopedic specialist, but when you also access chiropractors or pain management specialists, you have a lot more selection and a lot more people you can go to get your appointments as soon as possible. Also, chiropractors and pain management at times can produce a higher rating on the way of permanent disabilities at times. But from my point of view is that you have a lot more selection, a lot more people to pick from to get your case going, up and running.
Right, and I should add, recently the QME test in May, there was over 100 doctors that tested to be on the QME panel. A little over half passed, 58 passed. They need to take medical writing test, and then hopefully they'll be on the QME database that we could select from. So hopefully there'll be a whole bunch of new doctors out there. And one of my general strategies when I get a panel QME list and I don't recognize a doctor, I kind of take that as a good sign, because if you recognize the doctor, a lot of people will think they're either good or bad on either side, but hopefully the new doctors coming in will be more neutral like AMEs and get the case closed as quickly as possible. And so I've also found the same problems for accepted cases. And generally what I recommend to adjusters is try to get that panel right away. A landmine is to wait to send it out and have the defense attorney do it. If the adjuster could do it right away, do it right away. Send out your notices, wait your time, get your panel list. get it early because that avoids any chiropractor or pain management specialties that may not be the best for your case. And also another question is, do you want to get a panel QME list in another specialty now or wait? There's two ways to get a specialty in a panel QME list in another area. You can do it by written agreement if they're represented, or you can do it by a judge's order. For a lot of adjusters out there, they have cases that are unrepresented, and if you thumb through your labor code book to section 31.7A4, that's the process that an adjuster could work with an unrepresented worker to get other specialty areas in case there's a high blood pressure issue, a psych issue, eye or dentist, in addition to an orthopedic issue. 31.7A4, I'll just read it out from the code. In an unrepresented case that the parties have conferred with an INA officer and they've explained the need for an additional QME evaluation in another specialty area to address disputed issues, and as noted by the INA officer on the panel request form, the parties have reached an agreement in that specialty area, and then that request form can be sent in for the unrepresented worker, and that meeting with the INA officer could be in person or by phone conference. So if you do need another specialty area, that would be the process for an unrepresented worker. Schedule a phone conference with the INA officer, and you get that psych, dental or internal in another area. So Manuel, what's your general sense on applicants' attorneys on getting signing the agreement and getting that form signed to request other areas versus having defense stonewall and say we're not going to agree to it, you have to get an order? Any sense of which happens more often?
Well, from what I've seen, at least here in San Diego County, a lot of these judges don't want to piecemeal litigate, and they'd rather have all the specialties that are appropriate addressed in one hearing. And so they won't give us a trial, even though we have a threshold issue like statute of limitations or employment. I wish they would do that. I think it would be quicker and more efficient, because as long as you have at least one specialty addressing AOE, COE, whether the injury could have arisen out of this employment, I think you're ready to go. But I do find that we have to get the multiple specialties that are consistent with the alleged or pled body parts and medical conditions.
And the judges would issue an order for that specialty area in the different areas before proceeding to trial?
That has been my experience, yes.
And so generally, do you find that it's best then for everybody just to have the fight now, get everything resolved now, and have everything documented and try to get a trial at that time after the discovery is complete on all the different areas? And the judges would allow it?
That's what seems to be the case with these judges here in San Diego, because again, I think they want to avoid piecemeal litigation and having to address more and more denied body parts or medical conditions later. Although it would be nice if we could just have, for example, the principal body part addressed, AOE, COE, and go off to the races to get the issues addressed that are threshold issues instead of waiting for the rest of the appointments, because each one is going to delay the case even more.
Right, takes time and money and further delay on getting any treatment whatsoever, because theoretically we could agree that orthopedic QME may be substantial evidence and we're going to lose there, but maybe on high blood pressure and eye and dental, we feel confident we're going to win, but to delay the orthopedic treatment hurts your client and overall delays the case. And so the judges not allowing us to go to trial on that single issue does ultimately delay the case towards settlement.
I agree.
But again, the landmine to emphasize is to get your QME list early and often. Even if the adjusters out there referred the case out, feel free to get the panel QME list early, because you are the person that gets to select the specialty. 4061 PV disputes. You have to, if you want a panel QME list on an accepted case on a PD, you have to object within a reasonable time. Case law finds that's a couple months. And generally, you want to put some detailed analysis and information in your QME letters. If it's a PD and rating dispute, feel free to add AMA guidelines in there, and cite to the PTP report if you want. If you believe the PTP did an improper combination rating, used the wrong table, or something else, put that in your letter and describe what you think the dispute is. You do have to meet all timelines to send it to the other side on their 20 days before the eval and give the other side right to object. But from AA's perspective, do you find that AAs generally put a lot of time in the letter and try to put as much detail in the letter, or just kind of have a generic letter that they propose?
I find that having detailed information for the doctor to review will give the doctor direction as to what you, as the applicant's attorney, believe is important in this case with regard to the dispute, if it's 4061, as to what is important to take into consideration in coming up with the appropriate and accurate rating of the whole person impairment, and then ultimately permanent disability and apportionment.
And how often do you find a letter done by either defense attorney or adjusters go too far over where you would object to language or call them up and say, hey, can you change something? Does that happen 10% of the time, 50% of the time?
I'd say from my experience, about 10% of the time I get a letter that goes over the top, going beyond giving facts to really just giving an argument that is accusing, accusational as opposed to factual. But other than that, I typically don't object unless the facts are wrong that are being given by the defense advocacy letter.
Right, and from the defense perspective, I find the same thing. The letters I see are advocacy letters. They're generally okay. It's rare that I'll find something that is objectionable to. I think the doctors out there are savvy enough to read between the lines and pick up what we're trying to tell them. But having a detailed letter for all the adjusters out there is really key, and that's where you want to spend some time to avoid the landmine of not having a generic letter, because you're going to get a generic report back. If you want the doctor to address something, you should put it in there specifically. For example, a 4062, as you know, it used to be medical treatment, but it's not an objection under 4062 cannot be an objection to anything that's subject to 4610 and the UR process. The objection letter has to be within 20 days. And again, for the letters out there, feel free to cite to subpoenaed documents, the PTP report. If you want the QME doctor to review or comment on something, please put in there, please review the March 1, 2018 PTP report on page 10 that states XYZ. Please advise the parties if you agree or disagree. You could also mention, please review the MRI, the nerve testing. And what I like to do is when I take depositions, I get detailed information on the mechanics of the injury and where the complaints are and where the complaints and pain goes, because I find the typical injured worker isn't sophisticated enough to know the anatomical locations and how the pain and problems should progress. And so I'll put in a letter, please review deposition testimony page 40 to page 50 and comment if the mechanics of date of injury or subjective complaints are consistent with the objective testing. So that is kind of telling the doctor, look at the objective stuff, does it match the subjective stuff, and tell me if this person is lying or not. So I obviously, if I put in there, tell me if this person's lying, that's going to be an objection, but you cite to specific stuff that you think is inconsistent to bring it to the QME's attention. And for getting a QME list for the non-represented person, they have, once the notice goes out, the employee has 10 plus 5 days to request the panel list doctor. If they don't, the employer could request it after the 10 and 5 days. And once that time has expired, you could request, and then you're entitled to pick the specialty. So again, one of the strategies is to be the person picking the specialty. So don't wait until the injured worker becomes represented, because you would potentially get a chiro list. And once a chiro list has been generated, it's very difficult to avoid that unless there's some unique circumstance like a surgical candidate. There's a question on the objecting under 4060 versus 4061 versus 4062. There is different timelines. For a denied case, you just have to send a delay or denial letter and can get a panel QME. 4062 is for really, well, let me start with 4061. 4061 is really a permanent disability dispute. If you're disputing PD, there's a case that I think said 4 to 5 months was okay to object. Under 4062, there is a specific time in there that indicates 20 days is the proper time to object to under 4062 to get a panel QME list. Do you have anything to add on those dates or numbers?
Actually, I did want to say that you need to be clear in that 4062 is typically a denied body part or a denied medical condition that you're having to address, or temporary disability, where there really should be paid on a particular period of time. And the 20 days has to do with the date that you receive the treating doctor's report that brings up that additional body part or medical condition, or the fact that they're declaring the injured worker temporary totally disabled. And so that's why under 4062, where you would address those sorts of issues, you got the 20-day limitation, compared to 4061, where the injured worker has already been declared permanent and stationary, and at that point it's just a matter of trying to resolve the case based on the rating or taking it to the next level. So there's no 20-day limitation regarding 4061, but 4062, you do.
Right, and I used the shotgun approach. My objection letters list 4061/4062, and I list all issues under the labor code to include XYZ, so that covers my bases, and I always make sure it's within 20 days of the last report or the MMI report. So I'm safe on all bases when I do that, just as an extra protection. The represented process under 4062.2, either party can file a timely objection to the medical report and request a QME and request a specialty, like we talked about on the timeline. And the goal is really to be in control of the specialty that you get. The adjusters feel free to get that right away. Don't wait until the injured worker is represented. Don't wait until you send the report out to the defense attorney. Feel free to get those right away, because the control of the specialty is really important and kind of guides the case overall. If there is a panel list and they're unrepresented, they can get a new panel list once they become represented, as long as they haven't had the actual evaluation take place. And that would potentially open a door to a new specialty area if the eval hasn't taken place.
It's also important to make sure you get the proper medical specialty that you believe is needed for the case, because you're going to be stuck with that QME for the remainder of the case to address further issues. And so
right, it could be it's not, there isn't one orthopedic. There could be a hand problem, a knee problem, a back problem, that different areas that you want to request. Where is the biggest problem on the case can determine what specialty you request. And then once you get that panel list, you have 10 days to strike. And I've generally found everybody meets that 10-day requirement. I think initially people missed it, the first couple years, but the last 4 or 5 years, I think everybody has timely crossed out and struck. Has that been your finding?
Yes, that 10-day deadline is never an issue that I've come across.
Right, but so the adjusters out there, if you see that panel list, just know there's a different process for unrepresented and represented, and strike right away. So one of the important things in the QME process is to make sure the doctor has all of the records there. Before the evaluation, the labor code is 4062.3. All communications with the QME shall be in writing and shall be served on opposing party 20 days in advance before the evaluation. Generally, that's the minimum. Feel free to send it 30 days, 40 days, 50 days, depending on when the eval is set. The earlier the better. You have to list all the medical and non-medical documents you plan to serve. And then the other side has 10 days to object to the medical records. So you just want to watch out. The landmine is watching out for when the appointment is set and when the letters and information go out. Have you found most adjusters are meeting that 20-day requirement, or is there calls at the last second to say, hey, did you get it? Do you have any objections?
Well, when I get a new client and they've already had the QME, a lot of times I get told that they didn't get any records or anything like that.
Mm-hmm.
And I don't know for a fact what happened until I get the claims file.
Mm-hmm.
But typically when I do find that the 20-day requirement has been satisfied. I mean, it's a rarity that it isn't.
Right. And then after the evaluation, there's a case that kind of describes what communication is or isn't. If you read Labor Code 4062.3E, that's not the end of the case. There's a case out there on what is or isn't communication. So I would say the best practice is, even though after the evaluation, if you want to send something, send that notice to the other side 20 days ahead of time. Allow the objection time in case they do have a problem with what you're sending them, and that would avoid any potential problems on what is communication and what is not communication. Do you have any?
Yes, Greg. I think the case you're thinking about is Maxim, where it is dangerous because it can be considered ex parte communication, and that could result in having to replace the QME.
Right, and ex parte communication is bad. You don't want to ever do that. There's kind of different case law on what is ex parte communication, what is not. Generally, calling a doctor's office to set up an eval, the status of the report, I think is generally good. Anything beyond that is dangerous waters. Depending on how the report comes out, the other side is going to argue accordingly. If it's a good report defense, they're going to look for any possible reason to throw it out. If it's bad for defense, they'll obviously waive any ex parte communication. And the ex parte communication is held against the party, so you can't sabotage your own bad report. If the report comes back 90% 90% impairment, you can't call the doctor and have a phone conference and try to sabotage the report. That doesn't fly, and it would likely be sanctionable. And so in order to get all those records there, it's great to have a good team. A good part of the team is the subpoena company, and so I'd like to have MacroPro comment on what they could do and offer for the QME process.
Thanks, Greg. So MacroPro, I'd like just to toot our horn for just a half a moment, just celebrated our 30th year in business. And the interesting thing about that was, in doing so, we realized that a huge number of our employees have been with the company for 20 plus years, which means that they truly are experts in getting documents because they know what they're doing. There isn't a lot of turnover, and so it's a really great thing. So a couple of things I just want to make people aware of is that not every set of records can be gotten with an authorization form. And we think that they can, but unfortunately, the state of California did not put teeth in our authorization form when they redid the copy service reform. So if it's an insurance company or other locations, they can force you to use a subpoena instead of an authorization form, which makes no sense because the authorization form is a legal document that allows you to retrieve records. But the rule of thumb would be, if you've ever seen a commercial for them, dancing dogs, octopuses in the car, you know, cavemen, that type of thing, chances are you absolutely positively will have to use a subpoena for those records, even though you have a signed authorization. Then on the flip side, a lot of people would love to subpoena Uncle Sam. You can't subpoena Uncle Sam. So if you want to get records from the federal government, you have to utilize their forms. And any reputable copy service will have those available for you online. But let me ask you a question. For government records, how many authorization forms do you think you need as a rule?
Whatever it is, I would say it'd have to be in triplicate.
Touche. Any idea?
I have no idea.
Okay, so part of the reason people are not getting the documents that they want from the federal government is because they're providing, let's say, authorization to copy government records, hospital records. But you have to find those records. So before you could find those records, you need, Uncle Sam in his wisdom said, you need a special authorization form that says you can look for those records and then copy them. So I'm up from Sacramento. And so in Sacramento, we had 2 Air Force bases. We have Army Depot. We had a Marine detachment. We have Coast Guard, etc. A lot of those places are no longer there. Where are the records? Right? Where are they? The government doesn't keep them in one location. They could be in Florida. They could be in Ohio. They could be in DC. They could be just down here in Southern California. We don't know where they're at, so you have to have the right to search for them, and only after you've had the right to search for them do you have the right to copy. If you do not send those 2 documents together, you will never get the records. They're not going to match them for you. The other thing to keep in mind is government records are difficult to get. So if you're in the queue to get records, you want to make sure you have everything you need, because let's say you finally get to the front of the line, they're looking to get you your records and realize that there's something wrong with your authorization form, or it doesn't have the match set with it. Well, now they're going to send it back to you, so you can't provide these records for the following reasons, and you might have to wait another 9 months. So it's something to be completely aware of. But companies like MacroPro utilize every resource we possibly can to get those records as quickly as possible. We know the ins and outs. We know how to get these records. And so it behooves you to use a company that has been in business for a long time and understands all of that. A couple other things that they want to organize records. We have a really great program called MP Summary. And what can happen is an attorney or anyone might have 5 sets of records that they want to click a few buttons, and they can click those buttons and all those records would go up in the space, and when they landed, they would be in chronological order by type of visit. So it's a really cool tool that's available to everybody if they would like to use it. It's for those people who are very meticulous and want to be able to document everything. Like I said, it's a great tool.
And I find that tool is real helpful, because when you're looking at prior injuries, you need to match up the dates of injuries and events. If they reported an injury in January 2018 and they had a car accident right before then, that tool would point that out if they had treatment for a car accident and then reported a date of injury later.
Yeah, so a couple other discovery tools that we make available to our clients. If an examiner thinks that they didn't get enough information, medical records, etc., from the injured worker, they would be able to ask us if we've ever copied on them. We would not be able to release those records, but we would be able to say, yes, we have, and the records are located in the following places. And then they could choose whether or not they want to subpoena those records or use an authorization form, depending on what is valid. So that's one of the things that you can do. Another thing is film breakdowns. A lot of times the examiner, the attorney is saying, hey, we want all the information on the knee because that's where the injury is. Well, they never told you there was anything else, but all of a sudden you're getting a film breakdown and you can see that there was a back injury or maybe a hip replacement, something. So maybe you don't own as much of this claim as you thought you did, right?
Hopefully, a lot of apportionment.
Yeah, exactly. So there are things that you can do with a great record retrieval company like MacroPro that will help you mitigate some of your losses, and most importantly, pay what you're responsible for to make that injured worker whole. Because that's what we're here for, right? We're here to make that injured worker whole, and so whatever we can do as far as records are concerned, we want to do just that.
Right, thanks. And also, iLingo has interpreters and transportation. They're also part of the team in the QME process. So Sal, why don't you say something about your piece of the puzzle in the QME process?
Sure, thanks, Greg, for the invite to this webinar. A little bit of history of iLingo. iLingo 2 comes with the DNA from a company called 3i, which I founded over 25 years ago. iLingo 2 was founded by the executive team and operations team of 3i and been very successful across the country. So we have over 25 years of experience on how to provide language services to a variety of companies in the workers' comp or non-workers' comp space. Part of the regulations within California is that you are required to have an interpreter for appointments in the workers' comp space. That doesn't mean that you have to have an interpreter for every appointment. For example, physical therapy, you don't need an interpreter for every appointment there. In regards to the QMEs and AMEs and IMEs, you do need a certified interpreter at those appointments. The state does recognize that there are not enough qualified certified interpreters for these cases. So within their current rules, they're using a word that's called provisional certified. What does that mean? It doesn't mean that somebody has an actual number to be a provisional certified interpreter. Their certified interpreter should have a number that's issued by one of the authorizing bodies that the DWC has approved. The provisional interpreter is basically where the judge, the attorneys, or the TPA have agreed to send a provisional interpreter because for whatever reason, whether it's insufficient notice of the appointment, the geolocation, or the language, there isn't a certified interpreter available. So provisional interpreter can be sent to that appointment. The fee that you pay for a provisional interpreter should be different than what you pay for a certified interpreter. So when you look at those invoices, make sure that, that you're looking at that as well. There are some appointments that maybe the defense may not have to pay when using a non-certified interpreter. I'm not sure how often you've come across that or how often, Greg, have you opposed any of that, or Manny?
Well, I find that on a denied case, when it's a doctor treating on a lien basis, I found the interpreter companies they used are either non-certified or they can't produce the certification and say they're certified. And so when we get the liens, we look at, 6 months worth of treatments. They were present at all the evaluations, but if they're not certified, that's one of our defenses per the Gutron is that they should be a certified interpreter.
Correct. Now there's some pending rulemaking that has been in effect for the language industry for, I'm going to say, probably almost 10 years. And barely they had some public hearings on the new rates and on the new rules and on the new documentation requirements. We don't foresee anything being concrete on that till maybe sometime next year. We were hoping it would have been like 8 years ago, but in the meantime, people are still quoting the current rules that are in place. So it's very important that you deal with a very reputable language company who has the experience on having you maneuver through the waters of the uncertainty right now of the market for interpreters. At the same time, the notice that you give your language partner, the information for a QME or AME, IME is very critical. There is a shortage of certified interpreters. We get about 10% of requests for certified interpreters within a window of about 72 hours. It's crazy. Now, if it's in the geo area where maybe there might be one certified interpreter, it's going to be difficult. What's going to happen with that case or that medical appointment? It's going to probably have to be extended. So
you're saying an adjuster will call you up 72 hours before the appointment?
Within the 72 hours, we get about 10% of our book of business. That's within the 72 24-hour window.
Wow,
So
that's not a lot of time.
not a lot of time, and you have to take into consideration that some of these certified interpreters may only work at a particular law firm all the time. You may have 1,000 certified interpreters, but maybe only 300 of those we like to use for X reason. So it's very important that you get that information out to your language company so that they can fulfill with a certified interpreter or a provisionally certified interpreter, so that your QME doesn't get delayed or get thrown out. I'm not sure if there's ever been a case where a QME report has been thrown out because a certified interpreter wasn't used. Manny?
Not that I've handled, but it is a big problem. If you do not have a certified interpreter at a qualified medical examination or even an agreed medical examination. I've had problems when we have a primary treating physician during their final consultation to come up with the report, the comprehensive medical report that provides ratings and all the rest of the issues that we deal with. We like to have a certified interpreter at those as well, because they can be challenged. They can challenge the ability to communicate with the physician who's doing the work.
Correct. So the message here is control who your language provider is on to not only assure quality of service, which is very important. Adjusters are busy with phone calls, emails, so the less phone calls and emails that you have from your language provider makes your job easier. Sufficient time just to fulfill the certified interpreter request. In addition to that, you might have patients that for one reason or another cannot make it to their appointment. We also provide transportation services for those individuals, whether you have to fly them in from out of state or because of their back injury or work injury, they're unable to drive or have nobody to drive them to their appointment. We can also provide that service to you.
Well, that's great, because obviously having an applicant, injured worker show up at an appointment is critical to the process, and also having a great translator interpret everything, it really helps. So thanks a lot, Sal, for that info. The next slide, 4062.5, the QME report timeline. The QME must set an examination within 60 days of the request or 90 days by an agreement of both parties per the reg. Otherwise, either party could request a new panel QME. I do see that more often lately where the QMEs are so booked up that they can't set it timely. And so I've seen a lot more second panels request. You could use that as needed if it's a doctor you like. Obviously, you could do nothing and hope nobody notices. If it's a doctor you don't like, obviously press that code and request a new panel. One trick that I have up my sleeve that I don't like to disclose with an applicant attorney sitting in front of me is if I like the doctor and they can't set the appointment within 60 days, then I won't send out the notice until it is within 60 days and laid low, and hopefully applicant shows up at the appointment. The QME doctor is required to send out notice once the call comes in, but that leaves the burden up to applicant attorney to do the math on when the call went in and the appointment date to see if that's within 60 days. So that's just a thing to put in your bag of tricks, and hopefully there won't be a new panel request if you really like the remaining doctor on the panel list. What's your experience been on the QME setting within 60 days and not setting within 60 days?
I've been having more and more trouble getting the appointment set within 60 days. And as the party with the right to set the appointment, we can waive it if the doctor is the doctor I think is going to do a good job for the case to get it done. But we're limited to the 90 days on that. If we can't get it done within 90 days, we have to request a replacement panel.
Now, if you like the doctor, would you look the other way and try to proceed with the doctor that you like?
I could, but if somebody catches it later, it can be an issue for litigating whether or not it was lawful for the QME to perform the examination beyond the 90 days.
And the concern would be if the other side would still potentially have a bite of apple to blow up the report and argue that it wasn't set timely.
Right, because if you have, for example, a report that's that's giving 0, the applicant attorney can probably challenge it. And if you got a report that's giving you 100%, the defense is going to want to challenge it.
Right, and the goal is to resolve case quickly and avoid problems. And if you get, even though it is a delay of some time to get a new panel, it may ultimately save time if that's done up front. Is that your assessment?
Most definitely, because these panels are coming out fairly quickly, the replacement panels. They're not taking as long as they used to.
Right, for the adjusters, that not too long ago, well, a couple of years ago, I've been around 20 years, so not too long ago is a couple of years. We used to have to mail everything in, and it would take forever. Now we can get it online, and it's instantaneously if they're represented. One question we got is there a time frame or restrictions for setting a QME exam on unrepresented cases? Not to my knowledge that you have to set it within a certain time. The panel QME list is good for 2 years. Under the Reg 31.5, you could get a replacement panel after 2 years. And so that's why I generally recommend to get it early, because that panel list is valid for 2 years and you don't have to set it right away. You can see how the case plays out, but at least you've picked that specialty area up front and avoided a chiro or pain management specialty. Are you aware of any time restrictions beyond the 2 year?
No, if that is one of the 16 reasons for replacing the QME, that is that a panel issued more than 24 months ago and the panel never did perform an examination. That could be a basis for getting a replacement, as you're going to discuss probably later. I was going to ask you, have you had any issues dealing with medical records with unrepresented injured workers for when it involves a psyche panel?
Not really. The medical records, you get the subpoena, you get the records, and you supply them. Once someone files a psych claim, the door is wide open to their complete history, that anything has ever happened to them, even in childhood. Those are tough depositions because you have to get in their childhood, how they were brought up, has anything bad happened in their childhood, and you could do discovery from there. So all of those records are open, and we get them through good companies like MacroPro and send them to the QME. And so supplemental reports, going back to the slide, the QME supplemental reports must be served within 60 days of the request for the panel QME. If not, that could be a potential reason to request a new panel if they haven't complied with the regulations.
But, compared to the 30-day limitation, the 60-day limitation is a little bit more difficult in getting the QME panel replaced, because it depends upon what has happened in the case, how many evaluations have taken place, how many reports have issued, and I think it is very factually driven.
That's true, and I've had one judge deny a request because it was a date of injury a long time ago. There were several evals, and they basically said that in totality of circumstances, I believe that it should be a valid QME, and we're not going to allow a new one. So that is a potential out there depending on the case. Don't think that you could avoid that 100% case by just not having one supplemental, because there's probably, if there's been tons of evals and supplementals, the judges disfavor starting from square one again. And once the QME has issued the report and given a medical determination, well, we either have to follow it or object. Once its disputes resolved, defense must provide benefits or send the matter for a hearing with an application for adjudication or DOR. The alternative is to object, take the QME depot, try to attack their basis. And just because you potentially lose a medical issue, there's still a legal basis to deny a case and a factual basis to deny a case. Factual basis is basically credibility, that they're making the whole thing up. If I say I fell down a flight of stairs and I have pain in my knee, I'm obviously going to go to the QME doctor and say, well, doctor, I have pain in my knee from a fall at work. The QME is going to rely on that and say, okay, I believe they fell at work, they have knee pain, it's industrial, because they really have no other option. So you could still potentially deny and go to a trial on that factual issue. It's an uphill battle, but there's still that potential out there. And would you agree that a QME only resolves a medical dispute and not a legal or factual dispute?
Yes, I agree. They're not the trier of fact, and both sides really have the right to put on their case, to allow the judge to hear the testimony of the witnesses and make that determination, because it might be a threshold issue, including statute of limitations and employment and things of that nature.
Right, and that goes back to the discovery that you want to get all those records early on to fight the legal battle. If there's prior injuries out there, get those prior records, because your argument is it the prior injury that's causing the current complaints? And even though I fell down the stairs and injured my knee, is it simply a flare-up of the old injury, or is it a new aggravation and new injury that I'm entitled to new benefits? So getting that records and posing that question to the QME is real important. And so to backtrack a little bit, so if you don't object to the QME, provide the benefits right away, that moves the case a lot quicker towards closing by providing those benefits. And so some of you may be aware that we could potentially be on the hook for more attorney fees on a case under Labor Code 4064. The TPA is liable for attorney fees if an unrepresented worker later becomes represented after the defense files a DOR. The rule used to be where if defense filed an application for adjudication and they later became represented, would be on the hook for attorney fees. They changed that a few years ago, and now we can file the application to get jurisdiction to subpoena locations. But if we file the DOR and they become represented, the attorney fees are additional. So that means if you normally settle a $100,000 case, that would mean $85,000 goes to applicant and $15,000 go to the applicant attorney. But here, if you file a DOR, an unrepresented case that later becomes represented, then the $100 settlement, $100,000 goes to applicant and $15,000 goes to applicant attorney. So your total cost is $15,000. So the landmine to watch out for is if they're represented, how far along the stage do you want to go to avoid any potential attorney fees? And have you found out there in an applicant attorney perspective, is there a lot of cases that attorney fees are paid in addition to a settlement, do you think?
When it comes to this 4064 issue, it's a rare situation.
And that's been my case. I think I've come across that once or twice in 20 years, so it doesn't happen that often. But just to be aware of it out there. So can they get a new panel? 4067, you could get a new panel for unrepresented worker. We briefly touched upon it earlier that if an unrepresented worker has a panel list that hasn't actually gone through the panel QME evaluation, then they can become represented. They can not attend the QME and object to that and get a new panel QME list. So it's really, the trigger is really, have they had the actual evaluation with the panel QME? And there's a whole slew of reasons to get a new panel QME. For a represented person, it's regulation 31.5, section A. There's 16 reasons to get a new panel list. The ones I've typically found have been the doctor has failed to schedule the appointment within the 60 days. If applicant has moved to a new location, and also you could also get a different specialty area, like we discussed earlier, by having a joint agreement. The DIR has a form on their webpage that you could sign, or if one side goes to the court and gets a judge to issue an order to get a new area. And also, again, I'm looking at the last one, 31.5A16 is a reason to get a new panel QME is if it's not within 24 months of the issued panel. So that again, the panel list is good for 2 years out there. Have you found that the typical reason is that the doctors aren't studying within the 60-day requirement is the reason that most people request the a new panel QME?
Yes, that's a very common reason. Another one that you didn't mention is that the QME doesn't issue the report 30 days after the examination, and that's automatic pretty much. You can get a replacement panel.
Right, and the request, the 60-day requirement is in 4062.1 and 2 for the QME when from the initial call. And I think Diane was going to answer a question on a subpoena question that we got.
All right, well, first of all, I'm sure there are other questions and my email's not listed, so it's easy. It's diann@macropro.com. If you have questions, happy to answer those for you. The question is whether or not it was valid to copy the employee handbook. That would really be up to the examiner, their supervisor, management, and their attorney. But I can tell you that it can be copied, whether it's done with a subpoena and or a non-medical authorization form. That's one of the biggest things that we have a problem with. We always get a copy of a medical release form, but then they want employment records or they want to get other type of records, banking records. So you need to make sure you're using a general authorization form that will cover anything other than medical. And we got those on our website. If you need it, email me. I'll have to send it to you.
Thanks. And we also got another question. It was basically the reason why AA fees are paid when a DOR is filed and not the application for adjudication. And I think part of the reason they changed that is because defense needs jurisdiction to subpoena locations. And so the only way we get jurisdiction is by an application for adjudication. And so I think they changed that to defense having to pay attorney fees when we file a DOR, because then we're really pressing the issue on the case, and so they just allowed us to get our jurisdiction for records, but still some benefit to applicant out there when a hearing's coming up and they retain an attorney. So again, both of those were really rare. I rarely see those either way. So hopefully those were the biggest landmines to watch out for on the QME process. Ideally, to emphasize getting those QME evaluations and specialties early on that panel QME list for and controlling the specialty area is really significant and controls the case, and that's where I think the most important time is on the case to get that done early, so the adjusters can do that and not wait until the panel QME, before the employee becomes represented or the case litigated. And so let me ask you, Mr. Rodriguez, when you get a case and someone coming in, do you typically find a panel request has already been sent in, or no action has been taken to get the panel QME list?
Yeah, for the most part, nothing has been done. And
by the adjuster?
By the adjuster or anybody. Sometimes, I say about a third of the time, I do get cases where they've sent the QME paperwork to the injured worker that actually triggered them to see an attorney because they didn't know what to do about it. And so we take it from there and try to get the QME process going when the case is on delay. And I'd rather get a QME early as well. I think it's a good idea.
Right, and so let me emphasize again, because it's a missed opportunity for the adjusters out there when these injured workers are going to applicants' attorneys, that if you already have a specialty area locked up, that prevents the injured worker or applicant attorney from getting a chiro or pain management doctor. So that's, I think, the last thing I'd like to emphasize. If you have any other comments, generally. So, yeah, there's a question here that an injured worker was examined by a QME a year ago and still no report. So clearly they haven't met the 60-day eval. You would want to write a written objection to all the parties, and that would allow you to fill out the form to request a new panel list. So definitely that is way too long to wait for a report. So I would send a written objection to all parties, and then you could get the form on the DIR webpage. It's just a standard form you fill out and send in. So with that, I'd like to wrap it up. I'd like to thank everybody for contributing today, and thank you very much.
You're welcome.
Thank you.
Thank you all so much for joining us today. And thank you all for the wonderful questions. I think we were able to answer quite a bit of them. If there were any questions that were submitted that we weren't able to get to, we will email you a response. Just a couple reminders. I think the contact information for the speakers is on the screen today. If anything is missing that you'd like to have, please feel free to email any of us and we can provide any contact information.